Hello, I am back today to talk about settlement agreements, previously known as compromise agreements. These are legally binding contracts between you and your employer. A settlement agreement is usually entered into at the termination of employment and has the terms negotiated and agreed to between the parties. It usually provides for a severance payment by your employer, which may include your notice pay, a tax-free sum, redundancy pay, holiday pay, bonus, and other sums. In return, you agree not to bring any claims against your employer, such as unfair dismissal, discrimination, or breach of contract. There may be other terms included in a settlement agreement. This document can be totally binding in law, and because of its full and final nature, you need to ensure that your interests are properly protected. If you are presented with a settlement agreement, you should therefore seek legal advice from an independent solicitor who will explain the contents of the document to you and advise you on your rights in relation to negotiating the terms of the agreement, as well as after the agreement becomes legally binding. This meeting is a very important process as it determines many factors related to the agreement itself, along with what happens at different stages of the terms. Over time, I have been asked a number of questions such as, do I have to accept a settlement agreement? The answer to that is no, you do not. But it is essential to carefully consider the implications of accepting or rejecting the terms, taking into account factors such as financial compensation, job security, and potential legal recourse. Another question is, can I negotiate the value of my settlement agreement? The answer is yes, you can. Especially if there are grounds for improving the offer that you have been made, you have the right to negotiate the terms, including the value of the settlement itself. Negotiating is a very common practice and expected by employers and their legal representatives. Another question is, will my new employer know that I have signed a settlement agreement? The answer is no, they will not. Settlement agreements typically include confidentiality clauses that prohibit either party from disclosing the terms of the agreement to third parties, including future employers. You will generally get a reference guarantee in the settlement agreement that commits your employer to giving a specific form of reference to your new employer if the need arises. Another question is, do I need an independent solicitor to advise me? The answer to that is yes, you do. You are required by law to take independent legal advice from a solicitor. By doing so, you can ensure that you are making an informed decision regarding the settlement agreement and you are protecting your rights and interests throughout the process. Another question is about the legal fees. Who pays for them? The answer is your employer does. Usually they will contribute either towards or pay the full cost of your legal fees. This is standard practice and is outlined in the terms of the agreement. It is essential to choose a solicitor with expertise in employment law to ensure that you receive accurate, relevant advice tailored to your specific situation. If you have been given a settlement agreement, Portway Solicitors has your back and is here to advise you on all aspects of the agreement to ensure that you receive what you are due and to protect your rights. Until then, take care and thank you for listening.